One of the legal hurdles on the path to company succession is the allocation of the family business. An entrepreneur can assign his company to an heir. However, if the testator makes no binding provisions for his heirs regarding the division of the estate, allocation problems arise. Do not jeopardize the survival of your business. Act now. In corporate inheritance law, each heir's right to allocation of the company should have been introduced in the undivided estate. This should be if the testator died intestate. The company is the main asset, and the heirs cannot come to an agreement. However, the Council of State defeated this bill. Find out more in this video. My name is Tamara Freiner. I am an independent attorney at law in the Canton of Zurich. If this video appeals to you, please like and share it. The company must be continued from the death of the entrepreneur through to the division of the estate. If the entrepreneur suddenly passes away, a leadership vacuum arises. Several heirs form a community of heirs. The latter must decide unanimously. This may limit business operations. If an entrepreneur has not made any plans, an heir can apply to the court to appoint an heir representative to run the company. This is until the estate is legally divided, which can take a long time. What is the 10% rule and the judge's lack of allocation of authority about? If a testator dies intestate and the heirs cannot come to an agreement who shall take over the family business, each heir can bring an action to divide the estate. However, the court has only restricted competence. According to the Swiss Federal Tribunal, the inheritance distribution judge does not have the authority to assign any items from the estate to a specific heir. All heirs have equal rights. If heirs disagree, lots must be formed. The 10% rule is a hurdle. The different lots should not deviate more than 10% in value from an heir's statutory share of the estate. There may not be any excessive comprehensive payment to the co-heirs. Thus, a company must be either liquidated, broken up, or sold. The proceeds will be split among the heirs. According to the Swiss Federal Court, it is up to the legislator to provide for express legal competence for a court to allocate an individual property in an estate to a specific heir. The government submitted a draft on family business succession to the Swiss Parliament. It provided for an integral allocation of a company in the estate, provided that the testator died intestate without designating a successor, such as naming of a heir or bequeathing a legacy or through a binding division regulation. In addition, the heirs cannot agree on an amicable division of the estate. Under these conditions, the court should have the competence to assign a family business to a single heir who is willing to take over the company in its entirety. The criteria for judicial allocation were control and suitability. According to Article 617, Para 1 Draft Swiss Civil Code, every heir, whether alone or with other heirs, can request the allocation of the entire company or of shares that enables him to control the company. The allocation of the entire shareholding in the estate must be requested. Minority interests should not be left in the estate. So what should be achieved? One person should be given control of the company. Anyone who is already involved in the company has an interest in the continued existence of the business and its management. The aim was to continue the company and not to break it up. According to the draft, several heirs should be able to jointly request the allocation of the company or shareholding. An application for assignment would have to be submitted to the responsible court. The court would have to decide on the allocation. If several heirs do not request the company to be allocated jointly but rather individually, the most suitable one should have the opportunity to take over the business in its entirety. So who appears the best suited to run the family business? Criteria could include professional training, professional and management experience in the company or business area in question. Since the company is to be continued, criteria such as the age of the successor, their personal financial circumstances, and work in the company in question, knowledge of the market, customers, suppliers, and employees could also be considered. However, the Council of State defeated this bill to facilitate company succession on March 12, 2024. Thus, there is no safety net for unregulated or non-regulated estates that contain a family business. Even if there should be no special inheritance law for companies, there may be a provision regulating judicial division in the next revision package, so that the court could allocate individually and related items integrally to an heir upon request. The problem still exists. According to the Swiss Federal Tribunal, the Inheritance Division Court has, up to now, no authority to assign a family business to one heir in the division of the estate, even if an heir was willing to take over the company but the other one disagreed. Unfortunately, a company is still sacrificed in an inheritance dispute. It may be divided, split, or sold. Take the royal road. Tackle your company succession. Write your business will. Start now. Write down who your successor should be. Outline the desired succession process and appoint an executor. Don't sacrifice your life's work. Do not jeopardize the survival of your business. Take precautions. Give me a call. And please follow me on social media in order not to miss any news or insight. You find me on LinkedIn, Facebook, and YouTube. Thank you.